welcome to my channel. I'm Heather and this is Crime in Court, and I am here to give you an update again in the Delphi case, Delphi, Indiana, the unalivings of the 2017 unalivings of Libby and Abby. And currently Richard Allen is the suspect. He is incarcerated now in a prison where he should actually be in a county jail because he's only been charged with the crimes. He hasn't been found guilty of the crimes. So there's a whole issue as to his rights being violated right now. The judge that's overseeing his case recently, at the end of last year, threw his attorneys, they were public defenders, she threw them out of the case, basically gave them no other alternative other than to withdraw. And one of them did verbally in her office, while the other one said he would put his withdrawal in writing the next day. But he came back to court like on fire, ready to like take down Judge Gull. He went to the Supreme Court with this. The Supreme Court literally just ruled last week that she had no right to take his attorneys off and put new attorneys on. So they have been reinstated as Richard Allen's public defenders, which is big because they said they would even do it pro bono because they believe in their case so much and they believe in their strategic trial, the trial that they were going to take for the strategy that they were going to take for the trial. That's all kind of been put out there now in the Franks memorandum, which I am currently reading. I just did part 1 yesterday, so I'll link it to this video so you can go and listen to the part 1 of the Franks hearing, or the Franks memorandum, which has now become infamous. And that's the one that has to do with the Odinists, and were Odinists involved, and it actually alleges that some other people did it. So it's not just, it was this CULT, but it was also, here's the people that did it who are involved in this organization, this group. They're not a nice group. Anti-love group, let's call them. Or a religion. Some people call them a religion, and then some people call them an anti-love group. So anyways, so this, I'm here to, having said all of that, this document that you see before you is what Judge Gull just put out. She put this on the record. This is her response to any outstanding motions, which includes the Franks hearing, with a hearing which they requested in order to provide evidence for the fact that, they had all this, the investigation has been tampered, and they have this evidence to prove it, that the people that are involved in the investigation are corrupt and that kind of thing. So they had asked for this hearing to prove it, to show this evidence, and this is Judge Gull's response now that she's back, because the Supreme Court did not take her off of Richard Allen's case and assign a new judge, which I totally think that they should have, because how on earth are these attorneys that took her to Supreme Court ever going to get anything done with her? Because it really seems like she has a bias, and I wouldn't want to be in their shoes. So let me read this. This is Judge Gull's response from yesterday. She put this out. And this is very unorthodox. I'm going to post a link down below in the description, a link to Bob Mata's The Defense Diaries podcast. He did a great episode last night where him and another lawyer who actually has knowledge of Indiana law, they were discussing this particular document and the Supreme Court findings and all that. So I'm going to link that below. Definitely watch that if you're interested in learning more. then he's a great resource for this case. He's going to be at the trial following it, from day one. So, having said that, let's read this and then I want to hear what you guys think. Put your descriptions in the comments below. Put your comments below and let me know, what you think of this case, because it's shocking to me. Also, please don't forget to hit like, subscribe, and feel free to share this video to anyone that you think might be interested. All right, so this is the judicial officer from Francis Gull. She writes this yesterday, dated yesterday, January 22nd, 2024. The court, having had defendant's motion for Frank's hearing filed September 18th, 2023. So that's the Frank's memorandum that I was discussing. I'm going over it in separate parts because it's 136 pages and you guys don't want to hear me talk for that entire time. And I think I got through 17 when I recorded it, the first part, because it was a lot of talking. I had already done some recording for the day. So anyways, go check that out. I'm going to try to be releasing them, in quick succession to get them out, because I think it's good information to know what we're talking about here. So having the court having had the motion for Frank's hearing from the defendant, the memorandum in support of the accused motion for Frank's hearing. So they filed a memorandum in support of it for the Frank's hearing and the defendant's supplemental motion. So they filed yet another, like a supplemental information that wasn't in the first for the Frank's hearing, filed October 2nd. Defendant's additional Frank's notice filed, what was that? Additional Frank's notice. This one I can't recall off the top of my head what it was about. Obviously the motion to suppress, the state's objection to the defendant's motion to suppress, the state's second objection to defendant's motion to suppress. These are all motions and things that the defendants had outstanding at this point that hadn't been ruled on because we weren't sure who their attorneys were going to be. It's basically Andrew Baldwin is his attorney. Richard Allen's sitting just on ice. His case is has been sitting on ice ever since Judge Gull kicked Baldwin and Rosie off the case because she assigned new attorneys, but she was notified that was going to the Supreme Court, so nothing was really done, and they came up with like one or two filings throughout that time. And this is back in, I want to say October, she kicked them off. October, November. She kicked Baldwin, and when I say kicked off, she gave them literally no choice than to either resign or go out and humiliate themselves and ruin their reputation. So she set it up that way at this hearing. It appears that way, so that they would have to withdraw. Anyways, okay, so all these motions, she's taken them under advisement, now denies, here, let me scroll up. She now denies the defendant's motion for Frank's hearing. Big surprise, because we've been seeing a total bias and lack of due process on her part. So they should have at least, what Bob Motto was saying on his podcast was, at least in Illinois, when someone asks for a Frank's hearing, there's a hearing to decide if there's enough to have a Frank's hearing. So there's a hearing for a hearing. And that needs to take place first. But I don't know if that's necessarily true for Indiana law, but that's what it is for Illinois. So I wouldn't be surprised if it was similar there. But who knows? All right. So she denies the motion. The court finds the affidavit submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the murders would be found in the defendant's home and vehicles. So let me backtrack. The affidavit was submitted by law enforcement, and it's alleged in the Frank's memorandum that there was information that had been either purposely or in a way of neglect, it had been left out of the reports of what they submitted to the judge in order to get the search warrant completed or signed. So basically they're saying it's a faulty search warrant in the first place, and they never should have, they're trying to like quash everything because fruit of the poisonous tree. You got the wrong guy, first of all, but you also were lying or omitting specific information that you knew that was exculpatory to the defendant, or what showed that the defendant couldn't be guilty. They had kept it under wraps. And even when it had been turned over, according to the Frank's memorandum, that it had been sat on, and the defense team didn't get notified of that discovery when they should have been notified right away. Sorry, I'm trying to open my coffee and it's stuck for some reason. All right. Okay, so moving on. She says the affidavit, she thinks that law enforcement didn't lie on this evidence that he supported in the affidavit, and the search warrant was perfectly fine. So that's what she's stating here. The court does not find... oh, sorry, I missed a paragraph. The court finds the affidavit submitted in support of the issuance of the search warrant contained information that is reasonable belief. I just read that. The court does not find that the affidavit submitted false statements or that the affiant omitted statements with reckless regard, which is what the defense has alleged. Nor does the court find that the affiant intended to mislead the judge. So the judge does not think that whoever the affiant is, the law enforcement officer, I believe it's Liggett in this case, but it might be somebody else. I'm not through reading, we have to read further through the Frank's memorandum. I can't remember it off the top of my head, but I think it's Liggett, Sergeant Liggett, or detective, I'm not sure. So anyways, the judge is saying she does not think that there's anything wrong with the affidavit that was submitted by law enforcement, and she did not see any lies or anything like that. She thinks it's all on the up and up. She does not find them to be misleading or failing to present information. So she's saying, nope, they presented it all, even though the defense has evidence proving otherwise. So as the court, I'm going to have to hide myself because it's going to get lower here. So as the court has found that affidavit for issuance of the search warrant was valid, the search itself was reasonable and legal under Indiana law and Fourth Amendment case law. Defendant's motion to suppress fruits of search, so that's because the search warrant was not credible, it was, under false pretenses. The defense is saying you should completely throw out all of the evidence, because anything from the search should be thrown out. But she's saying the defendant's motion to suppress the fruits of the search of 1967, so that's just like the statute that they're talking about, filed May 19th, 2023, is also denied based upon all the pleadings, memorandums, and exhibits previously submitted in support of the request for a Frank's hearing. So she's saying, everything you submitted to me, I don't care, I don't want to look at. She even admitted in one of their hearings that she never read it. So, I mean, how much can she really be unbiased in this situation? How can she conduct a fair courtroom if she's already showing all this bias? I don't know. I really don't think that she can. I think she should recuse herself. Recuse yourself, Judge Gull. Recuse yourself. This is not fair what you're doing. It's absolutely awful. All right, so defendant's motion in limine regarding ballistics. So they're trying to basically keep a motion out regarding the ballistics of the casing. Remember, there's an unspent casing that was found near the girls or under one of the girls, and they're stating that they're finding that it matches back to Richard Allen's collection of ammo, of ballistic bullets and guns, whatever, you know what I'm saying. So they're saying, the defense is saying, we want to keep that out because it's junk science, basically. And it really technically is, because you can't say that every single firearm in the world is going to give its own unique individual. It's impossible. It's impossible, in my opinion, to say that the markings on the bullets are ever, and this one's an unspent bullet, so how does it even have markings? That's another thing that I want to know. So they're trying to keep this evidence out, and Judge Gull says this motion to keep it out is reviewed and denied without hearing. So she's not even going to hear why they want to keep it out, or why the fact that it's junk science, because it is. It absolutely is. There's, just like lie detectors used to be used to convict people, now we know they're junk science. Teeth impressions, also junk science. We know these things now. We need to do better instead of just going along with, oh yeah, ballistics, da da da. Every firearm has a unique, whatever, get out of here. There's no possible way you could say that, because you haven't been able to test every firearm. So it's just impossible to me. And I believe Ian Runkle of the Bailey has talked about this in depth on his channel, about how it's just not accurate science. So anyways, she's denying it, that it's coming in, which is totally prejudicial to the defendant, because no matter what, no matter how great of a witness the defense puts on to refute the fact that ballistics is junk science, it's still in their heads, and they're still thinking, oh yeah, that bullet matched that firearm, so now we know, and it's obviously his. That's how the line of thinking can be if you haven't been given the information in order to change the biases in these junk science experiments. So anyways, sorry, I didn't mean to get on such a high horse there about junk science, but I really hate it. So the court finds, and DNA is becoming that now with the whole SNP and STR and whatever, but I digress. The court finds the evidence contained in defendant's exhibits A and B attached to the motion is relevant and admissible. So she finds something relevant and admissible, whatever that is. The court further finds the probative value of such evidence is not substantially outweighed by its prejudicial impact, and that the evidence will not confuse or mislead the jury. So I think this is still talking about the ballistics, about how the junk science versus everybody's been thinking all these years ballistics is accurate science, when in actuality it hasn't been fully tested or vetted, or there's no way to actually prove some of the things that they do, and they can only say the markings on this casing are consistent with a firearm of blah 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 blah. They can't actually say, we can say definitively without a doubt it came out of this gun. So that's why I think it's, yeah, it is junk science. Anyways, The court further finds the probative value of such evidence is not substantially outweighed to the prejudicial impact. So they're just saying that they think that the evidence is good, it's valuable, it's not going to be that prejudicial to the defendant, and it's not going to confuse the jury. Don't worry about that. We're not going to mislead them in any way. Even though we're putting on a expert witness that is testifying to a science that has no validity. Maybe not no validity, but has little value, in my opinion. All right, defendant's motion to transfer. So that was filed January 2024, taken under advisement pending the state's response, if any. So this was from his new attorneys, and I did a video on that too, talking about how they were stating that Richard Allen got moved away very far, and it takes 3.5 hours or something like that to get to the prison alone, and it's a 10-hour day just to go visit him, and you only get to see him for an hour, and all this stuff. Plus, he's being mistreated very badly, mentally, physically. He's has very little interaction with humans, so he's like emotionally being affected and things like that. So they corroborated what Richard Allen's original attorneys had said about Richard Allen being mistreated in prison. So that, I think that says something, that they're corroborating the same thing. Anyways, the defendant's motion to transfer, it's under advisement right now. So that's the only thing that she hasn't ruled on yet, because she's waiting for the state's response to if they're going to object to moving him. And they had requested to move him to a county jail, and we're going to see what they say, because I believe this has been asked for before, was to move him to county, and it was denied. So we'll see what happens. I don't have high hopes for this judge, not even one bit. The state's motion to amend information will be set for a remote hearing. So I guess the state has a motion out there for some information to be changed, but I don't know what. It does not state it. But do you see, like, this is very, she doesn't state, I'm going to put my camera back on. She doesn't state case law. She doesn't give reasons for any of her denials. She just comes out and says, all these motions denied. So is it possible that she's going to recuse herself after she did this? Like, this was her last big F you for taking me to the Supreme Court. Here's everything denied. I think that it is an F you. Here's everything denied. And she tried to beat him to the punch, which is why it doesn't include case law or her reasons or anything like that. But it doesn't even say that they're forthcoming. So it doesn't say, like, she will give reasons why she's not doing a hearing. She's just saying, nope, not at all. So she's not stating why they haven't proven their case to get the hearing. And that's it. That is her full response there. So we'll see what happens. Like I said, I don't have a whole lot of hope. I really hope that they can renew their motion to ask Judge Gull to recuse herself. And I hope that she does, because she is so, like, her bias is just shining through. I mean, even the Supreme Court noticed. So I don't know. What do you guys think? Is Judge Gull just out of her mind doing these like quick motion or her quick rulings? I feel like she's not getting all the information, and she's being so dismissive of Richard Allen's team. So it's just wild how this is playing out. Just completely shocking and wild. And know that whether Richard Allen is guilty or innocent or even slightly had something to do with it, which I don't believe he did. Excuse me. let's say that he either, it doesn't matter if he's guilty or innocent. Let's pretend he's your cousin, your brother, your dad, your uncle, anyone in your family that you can imagine, yourself. Would you want to be in this situation where your attorneys have been shut down completely over and over and over again by a judge who keeps showing bias, not only just showing bias, but tries to get them kicked off of the case and sees no wrong in what she did? There was no egregious misconduct on their part. There might have been, a little slip up, but it was done by someone who was a trusted friend. So how was Andrew Baldwin to know that anybody was going to take photos and leak them? It's just wild. These cases, Delphi, Idaho 4, and if you're not paying attention, please go watch my Canton cover-up series. It is absolutely bonkers, the stuff that's going on there, and the feds are now they've been investigating the case, but it's just wild, the things that they're saying that is happening over there. So the feds are going to be coming out with information soon about what they have found for the Canton cover-up right now, which it might be a woman who is completely innocent that is standing to go to trial this March, and she is very likely, and all evidence points to, is being railroaded by the law enforcement in her town. Not just law enforcement, but also the district attorney's office. And that's kind of where the FBI is stepping in, and I think they're investigating the district attorney's office. That's pretty much the feeling of how this case was investigated. So this one, if you're not paying attention to the Canton cover-up over there in Canton, Massachusetts, Karen Reed is on trial for supposedly backing up into her boyfriend in a fit of rage and leaving him out in the snow to become unalived. So that is it's an ongoing case, and you might want to keep an eye on that because it's going to be huge very shortly. I think it's going to be breaking national news if you haven't heard of it already. So anyways, sorry to just get on rants, but I love talking about this stuff, and I hope you guys like to listen. Please let me know your thoughts below. Anything about the Delphi case, anything about Canton, anything about any true crime case that you would like me to cover, please let me know in the comments below. And don't forget to like and subscribe. I'll talk to you later. Bye.